warrant rejection of the agreement? Did the DPP abuse his discretionary power in negotiation and selection of appropriate terms of the plea agreement? Is the justification advanced by the DPP consistent with Article 157, Sub-Article 11 of the Constitution? When a dispute over an agreement of parties is committed to a court of law for interpretation, the primary province of the court remains to be interpretation and giving effect to the intention of the parties. This is the norm, and of course, for every norm, there is an exception. In this regard, there are decidedly limited inroads to this norm, except where vitiation facts such as illegality, in brackets, including but not limited to abuse of power and disregard of not only public interest, but also interest of administration of justice and the need to prevent and avoid abuse of the legal process, end of bracket, fraud, coercion, undue influence, or unconscionable terms are demonstrated. The quashing power of the court cannot deploy. Needless to add, mere assertions of illegality, abuse of discretionary power, fraud, coercion, undue influence, or unconscionable terms cannot suffice. Whereas judicial deference to the discretionary power reposed in the DPP is the norm, unsettling an act done by the DPP in exercise of its discretionary power is the exception. It's now a settled principle that whereas a court of law reserves power to inquire into how discretionary power was exercised by the DPP, if only to detect abuse or improper or bad faith or gross abuse of discretion or manifest injusticiable or palpable excess of authority, a court of law cannot dictate how the DPP exercises discretionary power. In the context of the plea agreement, in circumstances where the ODPP has properly exercised its discretionary power in entering into plea bargain agreement, it will be improper if this court substitutes the terms with its own preference without offending this time-tested principle. What's open to this court in the circumstances is to subject the plea agreement to the substantive legality test. Certainly, it's now a settled principle that the exercise of powers of the DPP, including but not limited to negotiation and entry into a plea agreement, including electing the options of bargaining under Section 137A, Section 1 of the CPC, cannot be exercised in a laissez-faire or whimsical manner, since constitutional power is constrained power. It follows that exercise of the DPP's power must surmount the triple test under Article 157, Sub-Article 11 of the Constitution. Accordingly, the test upon which acceptance or rejection of this plea agreement application turns is whether the reason or reasons advanced surmount the triple test resident in Article 157, Sub-Article 11 of the Constitution. The inventory of grounds upon which the DPP can exercise his power to discontinue criminal proceedings under pursuant to Article 157 of the Constitution and Section 137A Section 1B of the CPC has never and cannot possibly close any time soon, since the obligation reposed upon a court to develop the law under Article 259 of the Constitution does not envisage closure, provided that the ground or grounds advanced surmount the said triple test under Article 157, Sub-Article 11 of the Constitution. Now, the striking